And it usually ensures that the gay and lesbian plaintiffs' equal protection challenge will fail, which is quite the opposite when it's reviewed under strict scrutiny. Under strict scrutiny, usually it means that unless the government has a very strong argument that's narrowly tailored, the government will lose. So, although the Supreme Court has yet to directly address this question of what level of review under equal protection should be applied to gays and lesbians, the court has relied on a number of factors in determining which groups or categories should be classified as suspect or quasi-suspect to warrant this higher level of review. These factors include whether the group's defining characteristic is immutable, that it sufficiently defines the group as a discrete and insular minority, whether the group has suffered a history of discrimination, whether the group's defining characteristic is related to its members' ability to participate in or contribute to society, and the last factor, whether the plaintiffs are members of a politically powerless minority. And this is going to be the factor that I talk for the next couple of minutes about. In concluding that gays and lesbians are not entitled to quasi-suspect or suspect status, many of the opinions, lower court opinions, lower federal court opinions, and state Supreme Court opinions rely heavily on this last factor, this question of political power. And they usually argue that gays and lesbians are a politically powerful group, and therefore do not need protection from the majority. Okay? So for example, in 1990, in a case called High-Tech Gays versus Defense Industrial Security Clearance, gay and lesbian applicants for top security clearance positions challenged a policy that subjected them to extensive investigation that their heterosexual counterparts were not subjected to. And it also, the policy led to the rejection of top security clearance for, quote, known and suspected gays, end quote. The Ninth Circuit Court of Appeals held that gays and lesbians were not a suspect or quasi-suspect class because even though they had suffered a history of discrimination, homosexuality was first not an immutable characteristic, which was one of the other factors that I mentioned. And the court also said gays and lesbians were not without political power. They attract the attention of lawmakers. The court then proceeded to list four states and 10 cities that prohibited various forms of discrimination on the basis of sexual orientation to support its claim that gays and lesbians are politically powerful. No surprise, the court then proceeded to uphold the government's policy under a rational basis and granted their motion for summary judgment. In heavy reliance on this political power argument, often citing high-tech gays, federal courts and state Supreme Courts have upheld the constitutionality of laws denying gays and lesbians the benefits and privileges enjoyed by heterosexuals, ranging from laws that deny gay adoptions, same-sex bankruptcy protections, high-level security clearance, and of course same-sex marriage. And so there are several critiques. I mean, there are critiques of this argument as a doctrinal matter. There are many and varied, all right? But in the interest of time, I'm going to skip those arguments, and I'm happy for us to have a discussion about them later in the comment and the discussion time. But I want to really focus on what I think underlies much of the court's argument and what I referenced earlier. I think that this politically powerful argument that we see formulating in the lower federal courts and state courts that really essentially disregards the history of equal protection law on the basis of race and gender, the cases, I think. Really, this serves as a proxy for the popular stereotypes of gays and lesbians as white and affluent. I think that really what's underlying all this is this stereotype that is inaccurate as it applies to white gay men and also the rest of the community that makes up, the diversity of the community that makes up the gay and lesbian community. And so I want to talk about these, just to give you a brief example of this type of stereotype that we see, that we're not seeing articulated in the lower federal courts or the state court opinions, but of course we can always rely on Scalia to give us the real deal, all right? So I'm going to briefly talk about Romer versus Evans, Scalia's dissent in Romer, which most of you know are probably more familiar with Romer versus Evans, in response to a number of local ordinances banning discrimination against individuals on the basis of sexual orientation in areas like housing, employment, education, citizens of Colorado, by state referendum, adopted a constitutional amendment, Amendment 2. Amendment 2 not only repealed the local government ordinances protecting LGBTs, but it also prohibited all legislative, executive, or judicial action designed to protect gays and lesbians. In a 6-3 decision in Romer versus Evans, the Supreme Court, in a rare deviation from rational basis review, declared Colorado Amendment 2 unconstitutional as failing a rational basis test under equal protection law. The court held that it was not rationally related to any legitimate state interest and was basically driven by impermissible animosity against gays and lesbians. The dissent, authored by Justice Scalia and joined by Rehnquist and Thomas, blasted the majority for ignoring Bowers and Hardwick. He argued that, listen, Bowers allowed gave us constitutional permission to single out gays and lesbians for disfavored treatment. His other argument was that the amendment was not driven by animus, but an attempt to, quote, preserve traditional sexual mores against the efforts of a politically powerful minority to revise those mores through the use of the laws, end quote. He then later goes on to explain the problem, a problem that is for those who wish to retain social disapproval of homosexuality, is that because those who engage in homosexual conduct tend to reside in disproportionate numbers in certain communities, have high disposable income, and of course, care about homosexual rights issues much more ardently than the public at large, they possess political power much greater than their numbers, both locally and statewide. Quite understandably, they devote this political power to achieving not merely a grudging social toleration, but full social acceptance of homosexuality. So my point is to talk about this notion. I mean, I don't have to inject anything here. Scalia offers it for us. He says, hey, at the end of the day, this is a group that is heavily concentrated in certain areas of the country, has high disposable income, and what's interesting, if you look at the rhetoric from the right, from the Traditional Values Coalition, you see exactly that. It's like, the rhetoric in terms of building coalitions with other types of communities to defeat these initiatives is kind of runs parallel with this. It's like, they have high disposable income, they like to travel, if you cruise, they're doing all this stuff, they're going everywhere. And my argument is that embedded in these statements is not simply the power of heterosexism. It's not just heterosexism, but it uses the social construction of race, gender, and class as tools to reinforce heterosexism. Scalia and the federal judiciary and many of the state Supreme Courts, reinforcing heterosexism in equal protection law by first relying on a powerful white male and affluent stereotype of gay culture, which is inaccurate when we look at the statistics, but also ignores the diversity of the LGBT community. And in reality, these statements don't reflect the members of the gay and lesbian community. And so we're at a really interesting time, I think, because it's difficult to know what are the demographics of the gay and lesbian community, right? And what's the economic status of the gay and lesbian community? Well, UCLA Law School's Williams Institute has a team of social scientists who produce an incredible amount of data on the demographics of gays and lesbians, and the handouts that you have are their work product. And the primary source that I'm going to talk about today is estimates about gay and lesbian households comes from the United States Census. Not some like crazy, left-wing conspiracy, like the United States Census.